हुआ चल A very good afternoon. Uh, Hello. Yeah. A very good afternoon to one and all. Welcome to the sixth study circle meeting for 24-25. We have a very important topic today: the analysis and impact of the recent GIDC decision by the Gujarat High Court. Now, this decision, as you know, has far-reaching effect. It has a lot of our taxpayers are facing difficulties with related to MIDC. So I think this is the need of the hour, and I thank Dinesh Bhai for readily accepting our invitation and taking and providing his insight on this important judgment. Before we begin, I'll request the President, sir, to say a few words. President, sir.
Good afternoon. Thank you very much, Umang, LNR committee, Monaj on the dais, Joint Secretary Rahul Bhai, immediate past President Praveen Shinde, Office Bearer Sunil Joshi, Balram and dear friends. Really grateful to Law and Representation Committee for taking this subject very promptly and very immediately. And thanks to Dinesh Tambde, our past president, who has readily accepted our invitation. MIDC with 1 rupee lease rent to government assigned the rights to number of industries, associations, industries, and even some of the firms. Even my office is at MIDC. In Thane, there is in Asia highest means largest industrial area is MIDC is in MIDC Thane Vagheshed is the highest in number of units. Then there are various MIDCs across Maharashtra, and this is a landmark judgment. If you come across any of the assessees who has sold any of the properties in MIDC in last 6-7 years after the era of GST, they are calling the information. They are calling the information from the seller, purchaser, and from purchaser perspective also. They are going through entire record to verify that yes, it has been purchased, and gone through taking all the data regarding documentation, agreements, and payment details also. So they want to step into shoes of the recovery to recover the maximum amount as far as GST is concerned. Hardly 1 or 2 officer must have started this process, and they have started the levying the tax, and then GST department must have got the clue that this is the area where a lot of revenue can be generated. I think there is a various misconception, and various cases are pending across Maharashtra and Gujarat, and we had this landmark judgment. As far as GSTPAM is concerned, yes, we are into law and representation is a main focus. Wherever any difficulties are there, you must have seen that there were requirement of date of extension for 2 days, 3 days, as the case may be. There were glitches, and our law and representation committee is prompt enough to give that representation to the commissioner of GST as well as CGST, and we have got the extension time to time. And whatever issues are there which are facing by the members across Maharashtra, that also they are forwarding to the concerned department. There are other various activities going on. I request those who are online to become member. Even students committee is also, we are encouraging students to join hands with GSTPM. With these few words, I once again hand over mic to our co-convener, Umang Talati.
Thank you, sir. Before we begin the proceedings and I hand it over to Monarch Bhai for the introduction, just a couple of things. I just received a message from our member requesting that I announce this. MIDC Marol Industry Association is preparing a representation before state and central government with regards to the assignment of land being done at those places. So request was for any industry or your clients to join them and join the representation. Secondly, we have another study circle next week on the 22nd, which is also on a very important topic, the procedures and the issues with respect to the amnesty scheme, how to fill that form online, those practical issues that one may face. Because now that SPL 01 and SPL 02 is made available, that so for the amnesty scheme as well as for the rectification, that is going to be taken up next week, same time, 2 o'clock. So request everyone to be present. With this, I request Monarch Bhai for introducing our speaker for today. Thank you.
Thank you, Umang. Friends, to discuss today's topic, that is analysis and impact of GIDC decision of Honorable Gujarat High Court, we are having eminent faculty advocate Dinesh Tambde. Friends, the topic is very, very important because there is already a decision under the service tax era of the Greater Noida Industrial Development Authority. There is a decision of SIDCO as well of the Bombay High Court. In between, this decision has been pronounced by the Honorable Gujarat High Court in the matter of GIDC, which is of very relevance because there are, as the President Sir has already informed, that there are already a investigation and inquiry has been initiated for the MIDC and SIDCO plot sellers who has bought out these plots. So in this, it is my honor to introduce our today's eminent faculty, Advocate Dinesh Tambde, who has begun his career as a sales tax practitioner in the year 2003, and he started his practice under the firm name Tambde and Associates in the year 2006. He has served the GSTPAM Association as a committee member for a period of 14 years, and in the year 1920, he was the president of this esteemed association GSTPM. He has also served as a secretary of AIFTP in the year 1718. Currently, he is treasurer of Sales Tax Tribunal Bar Association, and during his tenure as a presidentship, he has formulated the GST diploma course of GSTPM affiliation with MNLU College. He has received a lot of awards such as Best Column Writer in GST Review, Best Group Leader in Intensive Study Circle Meeting of GSTPM, and he has also been awarded as a Best Paper Writer. So with this, I'm sure that we will be enlightened with the topic of today's, which is analysis and impact of GIDC's decision. With this, I am hand over the mic to Dinesh Bhai. And before this, I would like to present a request President to present memento to today's speaker, Dinesh Bhai. Now I request Dinesh Bhai to take up the session. Thank you.
Good afternoon, everyone. Thank you, Monarch, for calling me eminent twice. First of all, I thank President and his team, including the conveners, Mr. Monarch and Umang, for giving me this opportunity to learn the topic and present before you whatever that have come to my mind or whatever I have analyzed. This PPT contains 19 slides. Out of that, one is this covering slide and the last is the thank you. In between that, there are only 17 slides in which I have analyzed as to what one can accumulate or understand from the judgment of Gujarat High Court in case of GCCI. As rightly stated by Monarch, there are few judgments. There's judgment of the Bombay High Court, which is in existence, which is adverse so far as SSC is concerned. And there are judgments under the old era of service tax, which are in favor of revenue. And there was one UP AR, which is in favor of revenue. Considering that this judgment has come of the Honorable Gujarat High Court, slide जात नहीं है पुढे. हाँ. काय करायचं रे पुढे जायला? हाँ. अच्छा डाउन करो. Okay. Okay. So points that we have to consider while analyzing this judgment. Basically, one who would don't want to read the judgment of 290 pages. The judgment contains 290 pages. If one would go through my slides, he'll come to know what is there in the judgment in only 17 slides. As I stated, my first and last slides are the covering slides. So the points that we have to consider or have been considered in the judgment are basic law point involved. Then GCCI judgment, we will be seeing going through as to what are the things they have considered and what is the ratio laid down, what are the grounds they have considered, what are the judgments they have considered, that will go through. Then we will consider the Builders Association of Navi Mumbai judgment of the Bombay High Court. And then we will see the ruling under service tax. There's one ruling under service tax. And there's UP advance ruling. And thereafter, in the end, we will consider what is the impact of this GCCI judgment. Now, while considering the impact of GCCI judgment, we'll have to see whether should this judgment one should follow. Can this judgment be challenged in SLP before Supreme Court? What is recourse to the taxpayer? Then what is recourse if tax is paid in respect of old transactions? So these are the things that we'll be considering while going through the presentation. Now I will want you also to contribute if you feel like contributing, so that it will be the value addition and knowledge addition to everyone, including me. Points considered for determination. Then what are the points that have been considered for determination? Is levy of GST on assignment of leasehold rights of the plot and land allotted to the assessee by GIDC. That is, Gujarat Industrial Development Corporation has allotted plots to the entities. Whether the GST is leviable on that assignment of or allotment of plots, that point is considered in this judgment. then whether assignment of leasehold rights of the land along with building thereon would be covered by the supply of goods or supply of services. So first is the allotment of plot condition with condition that there would be a construction of a factory or shade or etc. If that condition is complied, then only that the allotee becomes eligible for that land, that whatever land is allotted to him. If that transaction is taxable, the second aspect that has been considered by the Gujarat High Court is this, that subsequent assignment of same land along with building is taxable or not to subsequent third party, subsequent lessee we can say. So whether that second transaction or is first transaction is taxable, whether the second transaction is taxable or not. Then thirdly, whether transfer or assignment of leasehold right is transaction of sale pertaining to immovable property or is supply of goods or services. So transferring of leasehold right is whether transfer of immovable property or it is supply of goods or services. That is the third aspect which has been considered in the judgment. Hope I am clear at this much. Now let us see what are the provisions which are there under the law. The judgment has considered the provision of section 7.1, which is inclusive, I would say, definition of or the scope of supply, which includes all forms of supply of goods or services, including lease for consideration in the course or furtherance of business. So in this scope of supply under section 7.1, even lease is included. Now 7.1a specifies schedule 2, which provides para 2a lease, tenancy, etc. in land is a supply. So if the land is given on lease, it is supply of service. That is what schedule 2 7.1a says. Then section 7.2 specifies schedule 3, which provides for clause 5, sale of land is neither to be treated as supply of goods nor supply of services. So sale of land is neither supply of goods nor supply of services. So this is the third provision which is relevant so far as this topic is concerned. Then fourth one is the entry number 41 in notification 12 of 2017, dated 28 June 2017, which is an exemption notification, which provides for exemption on one-time upfront amount in respect of service by way of granting long-term, that is 30 years or more, lease of industrial plot provided by state government, industrial development corporation, or undertakings to industrial units falling under chapter 972 of tariff code. So this is an exemption provided under the law, which says that if the land is given on lease for more than 30 years by the state government or the industrial corporations, then it is exempt from GST. So these are the four statutory provisions that have been considered while pronouncing this judgment. Now let us go to the GCCI's judgment, that is Gujarat High Court's judgment. What ratio is laid down in this judgment? The allotment of land, which is undisputedly an immovable property on lease, would be covered by clause 5A of schedule 2 of the GST Act, and therefore the same would be covered by scope of supply of services liable to levy tax under the provisions of section 9. So it is concluded in para 34 and 35 that when the land is allotted to an industrial unit on lease, maybe for long-term period, beyond 30 years or below that, it is a lease which is covered under clause 5A of schedule 2, and it's a service as per that clause 5A of schedule 2, and therefore it can be taxable. However, the same is exempt by notification 12 of 2017 at serial number 41. So transfer of allotment of lease by the government or industrial corporation to allottee or the industrial unit is a service. That is what is laid down or concluded by the Gujarat High Court. However, it says that in para 82.12 fine line of distinctions to be drawn for assignment of leasehold rights vis-a-vis allotment of plot land on lease by charging one-time premium. So it says that there has to be there is a distinction between allotment of plot on lease and assignment of leasehold rights. Assignment of leasehold rights is a subsequent transaction. Allotment of plot on lease is a first transaction, which is from the government or the industrial corporation to the allotee or industrial unit, which is taxable. It says that it is a lease in land and which is service as per clause 5A of schedule 2, and it is taxable, but it is exempt because of the entry 41 of notification 12 of 2017. However, subsequent transfer is a separate transaction which says that assignment of leasehold rights is a transfer of interest in immovable property, which would be equivalent to transfer of immovable property, would be covered by clause 5 of schedule 3. So subsequent transfer which happens, if suppose I am allottee and I have constructed some building on a plot, and I am transferring that land with the building to monarch. That transaction is transfer of immovable property, is in the nature of transfer of immovable property. If I am assigning that leasehold rights to monarch, then it is transfer of immovable property, and therefore it is covered in clause 5 of schedule 3, which is kept out of the purview of GST. That is what is held by the Honorable Gujarat High Court. Whereas renting of plot of land by GIDC would be covered by clause 5B of schedule 2. That is what we have discussed. So there are two transactions. They have differentiated the transaction. The first allotment they say is a lease and therefore is a supply of service which would be taxable but is exempt by entry 41 of notification 12 of 2017. And subsequent transfer of lease or assignment of lease is a sale of immovable property, is in the nature of sale of immovable property. Therefore, it is covered by exception in clause 5AB of schedule 2. This is what is concluded by the Gujarat High Court. Now let us go to the reasonings. What are the reasonings that are given by the Gujarat High Court to say that immovable property, it says that immovable property is not defined under the GST law. Hence, definition in other enactment has to be considered. So what they have done, since the immovable property is not defined, they have considered section 326 of the General Clauses Act, which says that immovable property shall include land, benefits arise out of land, and things attached to earth or permanently fastened to anything attached to the earth. So benefits that arise out of land is an immovable plot property or a land. That is what they are considered. So the rights of leasehold rights which are there in the land and the building is a benefit that arises out of land, and therefore that is an immovable property, transfer of immovable property. That is what they have concluded. Then they have considered section 3 of Transfer of Property Act, which says that immovable property does not include standing timber, growing crops or grass. So benefits arising out of the land is an immovable property. That is what they say. Then they have considered section 2 subsection 6 of the Registration Act 1908, which defines immovable property includes land, buildings, hereditary allowances, rights to ways, lights, ferries, fisheries, or any other benefit arise out of land, and things attached to earth or permanently fastened to anything which is attached to the earth, but not standing timber, growing crops, nor grasses. So any benefit that arises out of land is an immovable property, and therefore the transfer of leasehold rights are equated with the land and considered to be an exception for levy of GST under the GST law. Now, they have relied upon in para 62, they have relied upon the statement of objects which they have considered. They say that reading the provisions of the Act together and harmoniously to understand the nature of levy and the object and purposes of its imposition. No activity of nature mentioned in the inclusive provision of Section 7 of GST Act can be left out of the net of tax. So they say that scope of supply, that is Section 7, is inclusive definition, whereas they have specifically excluded the land from that definition of scope of supply. Allotment of plot of land on 99 years lease is a supply of service. So once the allotment is made, it is a supply of service which is covered under the scope of supply. But assignment of leasehold rights by excluding executing deed of assignment is nothing but transfer of immovable property. That is what they have concluded based on the definitions under the other law. So considering the objects, they say that the transfer of immovable property is not covered in Section 7 by way of Schedule 3, and therefore transfer of leasehold right in the nature of transfer of immovable property is not covered in the scope of supply. Now, in para 66, rate of tax notification, levy of GST on construction. Now, this is the rate of tax notification. They have taken reference of rate of tax notification, wherein they have excluded the land portion for taxability, which say that levy of GST on construction services are exclusive of 1/3 of the total amount charged for such supply, which includes transfer by way of lease or sublease, meaning thereby, even for levy of GST on construction services, value of land by way of lease is to be excluded, considering such value being value of immovable property which is transferred. So while specifying the rate of tax for construction services, if you would see the notification, it has provided the valuation provision, wherein they have stated that even if you are providing construction services on leasehold land, then you have to deduct the leasehold value of land, leasehold value of leasehold land for deriving the value of supply of services. So that reference they have taken in the judgment. Then they have considered the minutes of GST Council meeting. They have considered 5th GST Council meeting. I'm sorry. They have considered 5th GST Council meeting a specific proposal. Now, in the 5th GST Council meeting, there was a specific proposal which was made to impose GST on sale of immovable property on the ground that there was no constitutional embargo for imposing tax, and stamp duty was leviable on different aspects. So it was a discussion that was held in the 5th GST Council meeting that GST can be levied on land as well, as the stamp duty is on different aspect. That was the discussion which was held, and finally in that meeting it was concluded that not to levy GST on land. Then there was 7th GST Council meeting, of which the reference is taken. There also the same issue was discussed, and after detailed discussion, it was decided to defer imposition of tax on land and building. So GST can be levied on land and building, but it was deferred, purposely deferred. Therefore, they say that clause 5, which specifically keeps land out of the purview of GST, is the can clearly exclude, on the basis of that, it can be clearly excluded that sale of land and building, which is fortifies intention of the GST Council not to impose tax on transfer of immovable property containing the underlying object of erstwhile service tax regime. So under erstwhile service tax regime, GST service tax was not leviable on the immovable property. Similarly, under GST also, that the same, the GST tax is not to be levied on the land, and that is why they have taken these references of the GST Council meeting. Then there are some passing remarks which I found little confusing, that because Bombay High Court's judgment, if you would see, it has discussed or it has concluded only the first aspect, that is of allotment of lease. And allotment of lease is taxable as the same is taxable and specifically taxable under Schedule 2 as lease is a service. Therefore, and even in the Bombay High Court judgment, if you would see, the argument of the SSC was that the stamp duty, since the stamp duty is levied, it is a conveyance of land, it is sale of land, and it cannot be taxed. But that has not been agreed by the Bombay High Court. Here, in para 45, it says that considering the provisions of Transfer of Property Act, it emerges that immovable property would either be tangible or intangible right, which relates to plot of land. A sale is an absolute transfer or transfer by assignment along with whether interest lease lessee assigner is having on the land and building. So somehow they are trying to say that the transfer of leasehold right is the sale of land in a way. Then para 48, it says that the instrument of lease is liable to levy of stamp duty as per Article 30 of Schedule 1 of the Gujarat Stamp Act, where lease is more than 90 years. Same duty is prescribed as is leviable for conveyance under Article 20. So stamp duty is leviable, therefore it is conveyance. So the first transaction of allotment of lease is also in the nature of sale of land, but these are all passing remarks and not a judgment. As per provisions of Gujarat Stamp Act, instrument of lease is considered at par with the conveyance for the sale of immovable property. So these are all observations they have made, but somehow they have not overridden or contradicted the Bombay High Court judgment. In some way or other, they have passed remarks saying that the original allotment of lease is also in the nature of transfer of land or the sale of immovable property, but they have not concluded to contradict the Bombay High Court judgment. Now, there are some judgments that they have relied upon. In Gopal Saran versus Satyanarayan, reported in 1989, 3 Supreme Court case, it is held in that leasehold rights are nothing but interest in immovable property as per the provisions of Section 105, read with Section 108J of the Transfer of Property Act, constituting absolute transfer of right in such property, because transfer of such leasehold right extinguishes the estate of transferor, lessee, lessor in the immovable property, and all legal relationship with lessor, GIDC, are severed, and third party assignee becomes lessee, liable for obligation under the assignment deed and lessor GIDC. So when the subsequent transfer of leasehold right happens, all rights of the lessee get extinguished. All the rights in the land and building are transferred to the third party, and therefore it's a transfer of immovable property. That is what is concluded on the basis of this provisions of Transfer of Property Act. The assigner transfers leasehold rights after receiving consideration as determined on the basis of value of such leasehold rights. Such transactions, therefore, would be an immovable property and cannot be considered as a supply of service. So the transfer of leasehold rights is an immovable property. That is what is concluded in this judgment. Then in para 70, they have relied on Narinder S. Chanda and others versus Municipal Corporation of Greater Mumbai and others, reported in 2014, 15 Supreme Court cases 689. Words sale and service are not interchangeable terms. In this judgment, they have observed that Supreme Court has observed that sale and service are not interchangeable terms, as sale is defined under the Act to mean a transfer of property in goods for consideration, which would not include service, which would not refer to transfer of property in goods, but to service. So here they have tried to differentiate between the sale and services, because under GST they have discussed a lot on this in the judgment. Because if you would see the definition of service, anything other than goods is a service. That is what they say. That is what is the provision of law under GST law. GST says definition of service says goods is a transfer of property, transfer of ownership in a property, immovable property. So far as sale is concerned, and service is concerned, anything other than sale is a service. So can it be said that if the transfer of leasehold rights, if not, if the transfer of leasehold rights is not a sale, then can it be said that it is a service? That was the question before them. So they said that if it is specifically stated that sale of land is specifically excluded from the scope of supply of service, then it is a sale. It is a sale of immovable property. It's not a service. It is a sale of immovable property, and therefore it is not taxable under the GST. So there is a lot of discussion on this judgment made in the. Then they have relied upon the P. Kalisangam versus PSG College Technology. The definition that is inclusive cannot be said to be such wider to say that the same is extensive. In other words, inclusive definition cannot cover something that is excluded for levy. So this judgment they have considered to for the purpose that if you would see the definition in the scope of supply of service, the scope of supply of goods or services under section 7, it's an inclusive definition. So one can say that since it is inclusive, it can cover everything. But the judgments relying this GCCI judgment relying on this judgment says that something that is inclusive cannot be extensive to cover everything, even something that is purposely kept out of the purview. So land is purposely kept out of the purview, and therefore, even if scope of supply under section 7 is inclusive, it cannot cover the transfer of land, which in this case is transfer of leasehold right. Now, Anand Bera versus State of Orissa, a benefit that arises out of land and as such is immobile property. So here in this judgment, again, as we discussed, depending on relying on the other provisions under the other statute, that any benefit that arises out of land is nothing but a land. So similarly, in this judgment, it was laid down that the benefits that arise out of land are nothing but a land or the immobile property. Section 326 of the General Clauses Act defines immobile property as including benefits of that arise out of land. Then State of Orissa versus Titagarh paper mills. Here they have considered in this judgment the profit of pendre, the concept profit of pendre in land is nothing but a land. Profit of pendre in land means what? The benefit which are arising out of land is nothing but a land. So the leasehold rights, the rights that you possess is a benefit that you have out of that land. And if that benefit is transferred, then it is nothing but the transfer of land, and which is excluded for the purpose of GST under GST law in Schedule 3. Now let us come to the Builders Association of Navi Mumbai judgment. Now, as Monarch in the beginning had stated that there is one adverse judgment in the Bombay High Court in so far as Maharashtra is concerned. So what this judgment is relating to, the only one issue was involved in this judgment: levy of GST on one-time lease premium charged by CIDCO while letting plot of land on lease basis. So this judgment is concerning only one point, which is the SIDCO, when the SIDCO allots a plot to allottee or the industrial unit, whether that allotment and for that allotment, if something is charged, whether that amount is taxable or not under GST, whether tax is leviable on that or not. Now, while dealing, it was argued that Article 36, Schedule 1 to the Maharashtra Stamp Act, the impugned transaction is conveyance. So considering this Stamp Act provision, it was argued that allotment of plot is nothing but conveyance or the transfer of land, and therefore GST would not be applicable. But High Court held that SIDCO is a person. SIDCO has its own some duties to develop industry, etc. So a SIDCO is a person in the course or furtherance of its business, in the course of furtherance of business of SIDCO, it disposes of land by leasing them out for consideration, styled as one-time premium. So one-time premium is charged when SIDCO allots land, and therefore, if one refers to Schedule 2 of Section 7, then item number 2, styled as land and building, and any lease, tenancy, license, or occupy land is supply of service. So Bombay High Court has held that the allotment of land is nothing but a lease, and lease is specifically covered under Section 7, and therefore the same is taxable. That is what is held by the Honorable Bombay High Court. Now here it is pertinent to note that nothing is discussed regarding the applicability of exemption under entry 41 of the notification 12 of 2017. Because notification, as we discussed in the beginning, entry 41 grants notification to the allotment of leasehold rights for period of more than 30 years. So that exemption has not been discussed in the judgment. That I have not, nothing is there about this in this judgment. However, in the Supreme Court judgment, Supreme Court has not entertained the SLP. They have categorically observed that question of exemption, they have not examined the question of exemption. So nothing was before the High Court and Supreme Court, or nothing is concluded so far as exemption is concerned by the Honorable Bombay High Court and Honorable Supreme Court. Supreme Court says that we are not discussing anything about the exemption. Then further, they confirm the decision of Honorable Bombay High Court, but they say that the scope and ambit of expression clause 2A of Schedule 2, license to occupy land, we have not examined the scope of this terminology. License to occupy land is a supply of service or not. That we have not, the scope of it we have not examined. Though they have confirmed the decision of Honorable Bombay High Court saying that the allotment of land to a industrial unit is lease and it is taxable under GST, but they say that the scope of this 2A of Schedule 2 we have not examined. So these issues are still open before this, if it goes to Supreme Court. It appears that SLP was dismissed, confirming one-time premium being consideration for lease of land covered in scope of supply, but it did not examine the scope of Clause 2A of Schedule 2. So far as we discussed about the Gujarat High Court's judgment and Bombay High Court judgment. So distinction between the two is this, that Gujarat High Court has dealt with the subsequent transaction of assignment of leasehold rights, whereas Bombay High Court has not dealt with that aspect. Bombay High Court has not considered the exemption aspect, which is there in entry 41 of notification 12 of 2017. So far as Gujarat High Court judgment, what I can understand is this, it is clear that subsequent transaction of transfer of leasehold rights is not covered under the purview of GST, as it is considered as a Gujarat High Court is a transfer of land or the transfer of immovable property. Sorry, transfer of interest in land is, they have equated it with transfer of land. So that transaction which is specifically kept out of the purview of GST under Schedule 3 of the GST Act. So that is not taxable. But Gujarat High Court judgment has not contradicted Bombay High Court judgment so far as first transaction is concerned of allotment of leasehold rights. So the allotment of leasehold right position of so far as position as on today regarding the allotment of leasehold rights by the government or industrial corporation is the same as held by the Bombay High Court and similarly held by the Gujarat High Court, that the same is taxable. Now coming to the old judgments which Monarch said in the beginning, Greater Noida Industrial Development Authority versus Commissioner of Customs. You only will have to answer. ये दूसरा पार्ट करें.
So this is with respect to allotment. Does the Gujarat High Court judgment cover the aspect that so GIDC is formed with the object of creating industry, and it is done through a state enactment, right? And the list for the state has in its clause saying that you should do this, right? So then, per se, that other than giving the right, because the state owns the land, other than that right, which is the same thing which is happening subsequently, why is that not? Is that argued? Or
Sorry.
so list, yeah. So the list covers promotion of industries and all the infrastructure and all those things, right? So GIDC is created keeping that in mind.
That is the business of GIDC.
Right, that is a business.
Correct.
But it is still covered because the ownership continues to be a state government ownership, right? So then, how can allotment of land right to the original allotee be different from a subsequent transfer of the same right to another right? Does the judgment cover or do you have any views on it?
You mean to say the first how the first transaction is differentiated from the second transaction? See, first transaction, the aspect that you are saying is discussed in the Bombay High Court judgment. To say that that is the business of SIDCO, and while during the course of that business, they have allotted land, and therefore this is a service. That is what Bombay High Court says. So far as Gujarat High Court is concerned, I don't think Gujarat High Court has discussed anything about this. So, while differentiating these two aspects, what Gujarat High Court, the two transactions, the original transaction of allotment of leasehold rights and subsequent transaction of assignment of leasehold rights, they say that the first party remains the same, that is industrial corporation. Subsequent party keeps on changing, right? So the first party, that is the industrial corporation, is going to be a leasee forever. That is what they say, and they're going to get, either they have got a lease, one-time lease, or the periodical lease they are going to get. So far as the second party is concerned, who is a transferee of leasehold rights, he extinguishes all rights and interest in the that immobile property, and they have equated that extinguishing of all the rights and interest in the immobile property with the immobile property or land per se. So, so they say that the subsequent transaction is nothing but sale of land or immobile property, and therefore it is covered under exception. Should we go forward? In the first case, they say that it is specifically covered in Schedule 2 to say that when it is a lease for land or immobile property, it is a service, the law says. Whereas there is an exception, specific exception for land. And they have considered the definitions under the other laws, which say that benefit arising out of land is a land. So the leasehold rights is a benefit that arises out of land, and therefore it's a land which you are transferring, which is an exception of Schedule 3. See,
with the user service, how subsequent transaction can be handled and what covered as a service. This argument, I don't think will stand before Supreme Court.
For that, see, for that purpose, my personal opinion, I'll tell you. My personal opinion is this, that they have dealt with the issue exhaustively. About 210 pages, they have covered arguments on both the sides, what both the sides have argued. And in 90 pages, they have concluded what they wanted to say. And they have first relied upon the definition of immovable property to say that the leasehold rights is nothing but a land or the immovable property. But then first transaction, see, leasehold right, immovable property. I am a lazy. Suppose I am lazy, and I am a government. I am giving leasehold rights or transferring leasehold rights to Umang for lease. That is a consideration. That is the. But that is not permanent transfer, no. So far as second party is concerned, he is extinguishing all his rights. That aspect also they have discussed, that only because the exemption is given, it cannot be said that it is taxable. I'm trying to locate the relevant para, which sir is saying how they have dealt with that argument. That I'll just, if you have time, we can read that. Sorry, I have a lot of time. Great. In para 81, it says, I don't know if that is the correct para. I'll read para 81. The contention of the respondent that excluding only sale of land and building as per Schedule 3 would not amount to transfer of leasehold rights, as the interest in immovable property being an intangible form would be covered by scope of supply of service, is not tenable, as transaction of assignment is nothing but absolute transfer of right and interest arising out of land, which would amount to transfer sale of immovable property, which cannot be said to be. This is not the allotment वाला चाहिए. कहीं पे मार्क करके रखा था मैं. Para 17 I'll read, if that is, this is. Moreover, in the facts of the various cases, GIDC has only allotted plot of land to lessee who constructed building and developed the land to run the business or industry for which such plot of land was allotted. Therefore, what is assigned by the lessor is the assignee for the consideration is not only the land allotted by the GIDC on lease, but the entire land along with building thereon, which was constructed on land. The entire land and building is therefore transferred along with leasehold rights and interest in land, which is capital asset in the form of immovable property, and the assigner earned profit out of land by way of constructing and operating factory, building, shed, which constitutes profit a pendray, which is also immovable property and therefore would not be subject to tax under GST. Yes.
Just the issue involved in this particular case has been given under para 22, which specifically the issue is of the assignment of the lease. And first assignment. Therefore, they have not that and they have not distinguished that decision of the Bombay High Court in case of Cisco, which is the first. That is what he is asking. So in depth, they have not analyzed or they have not distinguished that.
They have not distinguished, they have not, para 35, I recollect, if I'm not wrong, para 35 foot C of the judgment, they say that the transfer of, for allotment of plot is the lease. So they are in consonance with the Bombay High Court. They are not contradicting Bombay High Court.
They have stated that what is allotment, what is assignment, they have distinguished all such things under para 82 itself. So that you are correct and you have answered that.
Findings are in both the judgments are contradictory. दोनों पढ़ोगे तो confuse हो जाओगे. So what is concluded is important for us. They have not contradicted Bombay High Court. They have not contradicted Supreme Court.
Exactly.
With this, let us go forward. याच्यात ना मला असं वाटतं पॅरा 75 एक बार बाद में पढ़ते हैं, होने के बाद देखते हैं कि why two transactions are separate. They have discussed it in the judgment. Now coming to Greater Noida Industrial Development Authority versus, here the issue was payment of service tax on rent, which had been received in the matter of allotment of plots by the assessee to use for construction of business commercial purposes during the term of the lease. Now here, while dealing with this judgment, they say that the case as it relates to the demand of service tax on renting of a movable property on lease for any period and term of lease under Schedule 2 of Clause 5, again they give the same reason for saying that this judgment is not applicable here. Under Schedule 2, Clause 5A, renting of immovable property is deemed to be supply of service. There is thin line of distinction between the renting of immovable property and assignment of such leasehold rights in immovable property for consideration. Assignment of leasehold rights for consideration in immovable property would be out of the scope of purview of supply of services, as it would amount to sale of immovable property in the form of land building, which would not cover in the definition of section 7(1)(a). So they, while saying that this judgment is not applicable here, they rely on the law and they say that the assignment of leasehold rights is nothing but transfer of land or property, that is immovable property. Now the Remarkable Industries Private Limited, UP advance ruling. ये कुछ और ही था यूपी का एडवांस रूलिंग. There is something else that, but then वो थोड़ा beneficial भी लग रहा था. Why? Because the activity they are held that the activity of applicant in the nature of agreeing to transfer one's leasehold right, it does not amount to further subleasing, as applicant's right as per the deed. हा डिफरन्स आहे की माझ्या सगळ्या राइट्स एक्सटिंग्विश होतात सेकंड ट्रान्झॅक्शन मधला डिफरन्स. As all rights as per the deed of sublease stands extinguished after assignment, neither does it create fresh benefit from the land. It is in the nature of compensation for agreeing to do the transfer of the applicant's right in favor of assignee. It is service classified under other miscellaneous services. The SEC code is given, taxable at the rate of 18%. That was held in that. This view could enable ITC. सामने वाले को ITC मिल जाएगा if this view is taken. So that was not, they simply not said that whether it is immovable property, not immovable property, it is agreeing to transfer something that benefit. So they are covering, they were classifying it under other miscellaneous services. Whereas GIC judgment disowned this interpretation, saying that consideration received by lessee assignee is not in the nature of premium, but it is consideration for outright sale of leasehold rights, which cannot be equated with subleasing in any manner. So it is a sale, simply sale that it says, and this view will disable the ITC. सॉरी नहीं, अगर मैंने समझो सपोज दिस GIC जजमेंट इज नॉट देयर, GCCI जजमेंट इज नॉट देयर, और आपने मुझे ट्रांसफर किया लीजोल्ड राइट, तो मुझे ITC नहीं मिलेगा, क्यों नहीं मिलेगा? व्हाई आई विल नॉट गेट ITC? हाँ, बिफोर दिस गुजरात हाई कोर्ट जजमेंट. I was stating it as taking it as a sublease. Okay. तो मैं नहीं लेता था ITC. तो ये यूपी का AR का अगर हम लेंगे व्यू, तो आई एम एलिजिबल फॉर ITC ना, वो व्यू लेंगे तो. ओके. So otherwise in the market no one is taking ITC on this.
सप्लायर को बोलता है तुमने टैक्स नहीं लगाया, अगर वसूल करता है, अगर टैक्स लगाया है तो रेसिपिएंट के पास जाता है क्रेडिट पे.
अच्छा.
Say it is like there will be alternative.
Okay.
For example, they are selling the whole for 5. They will say distributing the they are distributing the equipment that this one is for bidding. So for bidding, as if there is no GST. So for the balance, they charge accordingly.
Okay.
For balance only. That we were taking into some cases.
So lease they were taxing and
Balance
and subsequently they are not giving ITC. ITC was eligible. ITC should be eligible.
That's right. This is how we structured the transaction before GCCI, because Silco was still like $100, and technically speaking, ये भी Supreme Court में क्या होगा we don't. So what people usually do is that we say that we bifurcate it in the agreement that this building, say if the total value is 5 crore rupees, so this building factory along with the whatever the equipment so and so is 4 crores, and the land is 1 crore.
Okay, so they are bifurcating.
So then on 1 crore will be non-five. ITC used to charge, say, transfer fee for that. They are charging, say, for example, for 10% of value, they charge the land value, and they charge 10%. So that land value was considered as a development right now. They issue a receipt when you go for
Okay.
They issue the charge.
But then that is eligible for ITC or not? Yeah, you have to take no. Correct. हाँ. So if you are lease बोलोगे तो सब पे ITC मिलना चाहिए. Correct. Yes.
ट्रांसफर फी जो अलग से देते हैं ना 10% 20% वहां पर उसके ऊपर जीएसटी लगा दैट इज नॉट मीन इसके अंदर जीएसटी का भाई but essentially मैं आईपी एक सॉफ्टवेयर ट्रांसफर डेवलपमेंट राइटर मैं आईपी का जिसका नॉर्मल एडमिन चार्ज जैसा है सोसाइटी कैसे करता है फॉर वैल्यूएशन बट द नेचर ऑफ द ट्रांजैक्शन
So खत्म करते हैं. हाँ. हाँ.
और तुमने जो क्रेडिट लिया जो चार्ज किया वो तुम रिवर्स करेक्ट.
That is incorrect. Okay, now let us go to the last aspect of this session. Now impact of, let us just have some thought on the impact of this GCCI judgment. Should this judgment be followed? क्या लगता है? तो मैं बटन दबाऊं या नहीं? हाँ, judgment of GCCI is binding as the law is central. See, it is dealing with a new aspect which Bombay High Court has not dealt with. Okay. Law of the land as of now. So it has not contradicted Bombay High Court judgment in case of builder association. वो first premium वाला हो तो ICB exempt है. Entry 41 of 12 of 2017. तो वो बॉम्बे हाई कोर्ट भले आप एक्सेप्ट करो तो भी कुछ फर्क पड़ता नहीं है, एंड इट हैज नॉट कॉन्ट्राडिक्टेड. सो देयर इज नो प्रॉब्लम इफ यू एक्सेप्ट. legally it is binding and we can follow this judgment. That is what I feel. Then therefore the same has to be followed. Then second question that comes is, can this be challenged? Obviously, 100% it will be challenged. But how we can understand this can be challenged, because revenue had prayed for stay of the operation of GCCI judgment after pronouncement of the same by Gujarat High Court, which was rejected by the Gujarat High Court. This indicates that the same will be challenged in Supreme Court in SLP. Since immovable property is not defined under the law can be amended. That is what can happen, but it cannot be retrospectively amended, as explanation cannot be added to widen the applicability of levy retrospectively. So what lacuna in the law जो favor में आया SCC के, was that the non-availability of definition of immovable property or land. If they put explanation in Schedule 3, land means other than transfer of leasehold rights, तो वो taxable हो जाएगा. But that amendment cannot be done retrospectively when there is a elaborate judgment on that and which is followed by the industry. Then what is the recourse if tax is paid in respect of old transactions? Now what recourse one can have? Stamp duty is a different aspect. तू रामायण ऐकल्यानंतर राम कोण सीतेचे विचारू नकोस. नाही, we will discuss later.
You have to go for refund if it is not a supply in itself. Then question of GST cannot arise. The only question will be unjust enrichment. So as long as सामने वाले ने credit लिया था, उसने credit लिया, तो उसको पूरा दूंगा.
What about GST that is paid on assignment of leasehold rights, and what if ITC is claimed on the same? What Umang said, can refund be claimed on tax collected and paid? Yes. Should ITC be reversed if the same is claimed? Yes. So with this, I think I have dealt with the duty assigned to me, and therefore thank you so much for giving me opportunity. Thank you, thank you. So you will only have to answer questions. This is a good question. This is good question. Yes, yes. I skipped in my this before you. I don't want to give you credit. So this transaction, it can be framed in such a manner as a transfer of business. If you frame this transaction in the manner of transfer of business, then you are entirely out of the whole thing, whole dispute. This is good. This is good. That I somehow skipped from my mind. वो technicalities में बहुत जाते हैं ना, सब learned है तो लगता है कुछ गलत बोल दिया तो लफड़ा हो जाएगा. Going concern, you will be out of the purview of GST. Transfer of business कर लो, अच्छा है. You can frame. प्लम से लो सकते हैं. और कुछ है?
So first, Mumbai High Court has said that it's a taxable transaction. It was particular that notification 41 has got into exemption. But is it a way of thinking, like taking a note of it, that 243W, that is sovereign function, like delivering the sovereign function. So certified all authorities are under the sovereign function, basically to develop the industry and this and that. So will it be covered under RCA if it is under 41 as exempted transaction? But will it be got under RCM transaction? Like, we are not deciding the forward tax, but it can be considered reverse tax.
That aspect has to be dealt with, and to be हाँ give
If
mic ले ले ना तो
rate of tax on the output side is zero, it even if it has to be zero, right? So then the question of RCM cannot. RCM कब होगा जब एक्चुअली में टैक्स होगा तब.
No, if the or purpose of activity is that there is a exam parameter. Okay. But when you look at the other way around, that is discharging of certain function by local authority, there is the whole intention is not the leasing of the property, it is discharging of the sovereign function. So when that comes into
but then if that is exempt,
yeah.
if that is exempt, see whether it is sovereign function or not is the question to examine. So if we presume that that is sovereign function, and if it is exempt, then where is the question of RCM?
And the payment or any authority is considered to payment to government authority.
No, but then if this is the
That is why you got under forward plan.
The point is, suppose there are two entries. Okay, one is discharging of sovereign function. The other one is providing services to government entity or government providing you service. Okay. Now in this case, which is the more proximate entry, which is the more specific entry? That is the sovereign function. So then you not go to the second entry.
so exemption मिल जाएगा दोनों तरफ exemption. Yes. और हो गया. Thank you everyone. Thank you President sir and thank you conveners for the request that I had made not to give huge mementos. Thank you so much. Henceforth you start giving something valuable which will be useful. Thank you.
Thank you, Dinesh bhai, for excellently taking us through this very important judgment. I think this has quite far-reaching effect, and as we discussed, there is a very high chance that this will go to Supreme Court. But fingers crossed that this stays, and actually it is the right way to look at it. So thank you for giving your valuable input and time. Small announcement. We have the next study circle. So next Wednesday on the 22nd of January, we are taking another study circle. It is going to be led by Abhijit Berde, and it is on the issues and procedures with respect to the amnesty scheme and the rectification which is to be done, with specific focus on the filing on the portal, so that any issues that we get on the portal that can be resolved, small typical issues that we face. So that is going to be done. It is next week on Wednesday, 2 to 3:30 p.m. Sunil bhai? Sunil bhai has some announcements, sir.
Wait or not, I just want to announce that we are considering RRC early bird discount till coming Monday, and someone who already missed the bus can join now for the RRC. So it is online as well as offline payment modes are available. Please join.
So RRC early bird is extended on a lot of requests for our members. So it is requested everyone please avail this as early as possible. It is extended till Monday. And we have one more announcement.
Good afternoon, everyone. Well, this was an announcement for International RRC at Baku, Azerbaijan, to be scheduled in the month of May 2025. We are very pleased to announce that we have received an overwhelming response from members, and the first group that was supposed to depart on 28th of May is completely full. And now we have also started the second group, which is also nearing to be full with very few seats left. So I request the interested members, if want to join the RRC, please make enrollments at the earliest. to avoid disappointments at the last moment, because it is very difficult to get flight seats, because May being a peak season in Baku, there are very limited flight seats available. Hence, any interested members, please do come forward and make enrollments at the earliest. Thank you everyone. Have a good day. Yeah, yeah. The second group which is there will leave on 2nd of June, and we will be returning on 8th of June. Thank you everyone.
So with this, we conclude today's study circle session. See you all next week at the same time. Thank you. We rise for the national anthem. Jana Gana Mana Adinayak Jaya He Bharat Bhagya Punjab Sindh Gujarat Maratha Dravid Vindhya Himachal Yamuna Ganga Uchchal Jaladi Taranga Tav Shubha Name Jape Tav Shubha Ashish Mage Gahe Tav Jaya Gata Jana Gana Mangal Dayak Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 Jaya